Hi, I'm Darren Brewer with FreightSpin. Today we're beginning a two-part series exploring one of the most important and still unanswered questions in transportation law. Episode 1 traces how we got here. Episode 2 explores what reasonable care may actually require when freight brokers select motor carriers. So let's begin with the story behind one of the most significant legal questions facing the freight industry today. Over the past 22 years, 3 legal events have reshaped the conversation surrounding freight broker liability and carrier selection in the United States. All 3 involve the same company, C.H. Robinson. But this is not a story about C.H. Robinson. It's the story of how transportation law evolved from asking whether freight brokers owe any duty at all when selecting motor carriers to asking one of the most important and still unanswered questions in transportation law. What does reasonable care actually require of a freight broker? And perhaps even more importantly, who gets to answer that question? Congress? The FMCSA, the courts, private industry, or 12 jurors sitting in a courtroom. Today, we'll trace that legal evolution through 3 defining chapters: Schramm, Montgomery, and the recent Dallas County jury verdict that has the entire freight industry talking. That's significant. In order to understand where we are today, we have to go back more than 20 years. In 2002, a catastrophic crash occurred in Maryland involving a truck that had been arranged by C.H. Robinson. The resulting lawsuit eventually became the landmark federal district court case known as Schramm versus Foster. Before Schramm, many people viewed freight brokers as simply arranging transportation. The court agreed that C.H. Robinson was not automatically responsible for the actions of the carrier or its driver, but the court also made an important observation. It concluded that the negligent hiring claim could proceed. Why? Because the court concluded that a freight broker arranging transportation may owe a duty to exercise reasonable care when selecting motor carriers. That was significant. The court discussed reviewing available federal safety information, maintaining internal carrier records, and even watching for related companies attempting to escape poor safety histories. In the Schramm case, it's important to understand what the court did not do. It did not define the freight broker's responsibilities. It did not say every broker must perform the exact same review. It did not hold that every accident creates broker liability. Instead, it introduced a legal precedent that would shape transportation law for the next 2 decades. A freight broker may have a duty to exercise reasonable care when selecting a carrier. But what exactly does reasonable care mean? That answer remained uncertain. Now, fast forward more than 20 years. Again, C.H. Robinson found itself at the center of another landmark case. This time, however, the question was completely different. The issue wasn't whether the freight broker acted reasonably. The issue was whether the lawsuit could proceed at all. For years, freight brokers frequently argued that negligent carrier selection claims were preempted by the Federal Aviation Administration Authorization Act, commonly called the FAA. Courts across the country disagreed. Some allowed those lawsuits. Others dismissed them before juries ever considered whether the broker acted responsibly. That changed on May 14th, 2026. Just a few months ago, the the United States Supreme Court issued its unanimous decision in Montgomery versus Caribe Transport II. The court held that the FAA did not categorically preempt state law negligent selection claims against freight brokers because Congress preserved state authority over motor vehicle safety. That decision fundamentally changed the litigation landscape. For years, preemption had been one of the freight broker industry's most important threshold defenses. Montgomery didn't decide whether C.H. Robinson exercised reasonable care. Instead, it answered a different question. It held that those negligent selection claims are not categorically barred by the FAA and may proceed under state law. In other words, the Supreme Court answered the preemption question. It did not answer the reasonable care question. The courts once again did not define a national carrier selection standard. It did not establish mandatory inspection thresholds. It did not require freight brokers to analyze CSA data. It did not establish minimum basic scores. It did not explain how much weight should be given to crashes, violations, authority history, fraud indicators, or ongoing carrier monitoring. Did the court even have the authority to establish those operational requirements? Those questions remain unanswered. The courthouse door was now open. At this point, Congress had not established a statutory standard defining what operational steps freight brokers must take to satisfy reasonable care. Then came July 2026. Only a few months after the Supreme Court's decision in Montgomery, another major legal event captured the freight industry's attention: the Dallas County verdict. Shortly thereafter, a Dallas County jury was asked to evaluate a freight broker's carrier selection decisions. The result was an approximately $604 million advisory verdict involving freight broker C.H. Robinson, motor carrier Lupus Superior, and the carrier's driver. The verdict consists of compensatory damages, not punitive damages, and it has not yet been finalized by the court. The jury apportioned C.H. Robinson's several share responsibility at approximately $139 million. The approximately $604 million advisory verdict resulted from the jury's additional findings that C.H. Robinson was legally responsible for the third-party driver's conduct. C.H. Robinson disputes that finding and has publicly stated that it intends to appeal. So this is not the end of the legal process, nor could a jury verdict automatically establish a nationwide legal standard, but the advisory verdict remains highly significant. Why? Because it may represent one of the first major opportunities to see how a jury evaluates a freight broker's carrier selection decisions after Montgomery. In other words, Montgomery opened the courthouse door. The Dallas County trial shows what can happen once a negligent selection claim actually reaches a jury. Whatever the ultimate outcome on appeal, the case illustrates how juries may evaluate negligent selection claims once they reach trial. When negligent selection claims reach trial, juries ultimately evaluate a freight broker's carrier selection decisions, not its marketing slogans. Ultimately, the motor carriers a freight broker chooses to haul its customers' freight reveal far more about its carrier selection standards than any safety-first message could ever deliver. That leads us to an extremely important question. What operational requirements, if any, has the law actually established for freight brokers to satisfy reasonable care? And this is where the real discussion begins. If Congress has not established a statutory checklist, what should freight brokers actually be evaluating by law? Should they simply verify that the carrier has active operating authority? Are freight brokers legally required to inspect carriers' insurance by law? If the carrier provides an insurance certificate, is that enough? Or how much insurance, which coverage policies, limits, should they rely on FMCSA safety ratings like the carrier safety rating or basic percentiles? Or should they also examine roadside inspections? Should they be required to obtain inspection records from individual states for intrastate carriers whose inspections often are not reported to the FMCSA? And there are other considerations. Violation history, crash history, out-of-service percentages, CSA basic categories, authority history, insurance history. Oh, what about truck VIN number history, trailer VIN number history, proof of ownership, and new equipment purchase records, registration cards, cab cards, trailer registration cards, and equipment lease agreements, related companies, identity verification, fraud indicators, internal performance history. Should carriers be reevaluated regularly? Should every decision be documented? The truth is, Congress has not created a universally applicable checklist. Courts are not supposed to have the authority to create new law either. And that's exactly why this area of law is bringing so much into question. Interestingly, after Montgomery, C.H. Robinson publicly described additional steps it says it takes in its carrier vetting process. The company stated that it reviews carrier authority, federal safety ratings, insurance coverage, conducts an internal safety analysis, and regularly reevaluates carriers with the goal of exceeding the standard of reasonable care. That statement's worth thinking about. It doesn't establish the legal standard for every freight broker, but it illustrates an important reality. When the legal boundary is uncertain, companies often choose to build processes that go beyond what a court may try to define as the minimum requirement. But after studying Schramm, Montgomery, and now the Dallas County verdict, I found myself asking a completely different question. And frankly, I don't think enough people are asking it. Congress created the Federal Motor Carrier Safety Administration, the FMCSA. Congress gave the FMCSA the authority to register motor carriers, to grant and revoke operating authority, to conduct compliance reviews, to issue official safety ratings, to determine whether carriers remain authorized to operate in interstate commerce. Congress did not assign those responsibilities to freight brokers. Freight brokers do not control or decide who receives operating authority. The FMCSA does. Freight brokers do not revoke operating authority. The FMCSA does. Freight brokers do not issue satisfactory, conditional, or unsatisfactory carrier safety ratings. The FMCSA does. So here is the $604 million question. If a jury concludes that a freight broker should have recognized safety risks that the FMCSA itself did not determine warranted revoking a carrier's operating authority, what legal recourse, if any, should a freight broker have if a jury concludes it should have identified safety risks that the FMCSA itself did not determine warranted revoking a carrier's operating authority? To be absolutely clear, I am not suggesting the FMCSA becomes automatically liable whenever a carrier causes a crash. And I'm not suggesting freight brokers should rely exclusively on a carrier's operating authority, or exclusively on a safety rating, or exclusively on CSA basic information. Those are different questions. My question is much narrower. Congress entrusted the FMCSA, not private freight brokerage companies, with regulating who may lawfully operate as an interstate motor carrier. If freight brokers cannot reasonably rely, at least in part, on those federal regulatory determinations, what did Congress intend for those determinations to mean? Where does the FMCSA's legally established responsibility start and end? And where does a freight broker's responsibility begin? We have definitely not reached the end of this story. Actually, it's just the beginning. The Dallas County verdict will almost certainly be appealed. Future court cases will continue to explore the scope of freight brokers' responsibilities and what reasonable care ultimately requires. Technology will evolve, carrier vetting will evolve, private safety analytics will evolve, industry practices will evolve. And eventually, appellate courts or perhaps Congress or the FMCSA itself may have to answer the question that remains unresolved today. What does reasonable care actually require of a freight broker when selecting a motor carrier? Is there a defined explanation of reasonable care that's currently required by law, as established by Congress, or cited in the FMCSA Code of Federal Regulations? Presently, the answer is no. And that uncertainty is exactly why this conversation matters. That answer will shape freight broker liability for years to come. And I suspect the next decade of transportation litigation may ultimately be spent defining two words: reasonable care. 22 years ago, Schramm introduced the idea that brokers may owe a duty of reasonable care. Montgomery confirmed those claims can proceed. Now, the Dallas County verdict demonstrated what can happen when a jury evaluates those decisions. But perhaps the biggest question still has not been answered. What does reasonable care actually require? And who ultimately gets to decide? That's exactly where we'll begin in episode 2. So thank you for watching, and I'll see you in the next episode.